Can I be sued for something my husband or wife did in Illinois? There is an old saying that goes lucky in life, unlucky in love. And for many Illinois spouses, that phrase carries very real financial consequences. When your spouse's poor decisions lead to lawsuits, debts, or legal judgments, you may be wondering whether their liability can legally become your own. Under Illinois law, if you are still married, a court judgment issued against your spouse is treated as a marital debt that both parties may share. Illinois Statute 750 ILCS 500 thirds. It defines marital property to include all debts and obligations acquired by either spouse after the marriage began. This means that if your spouse is a walking liability, you could one day be personally responsible for paying a portion of that debt. However, the division is not a simple 50-50 split, because courts weigh each party's contribution and whether one spouse's negligence caused a decrease in the total value of marital property. Illinois courts may also treat the expenses of a lawsuit as dissipation of marital assets, potentially entitling the non-negligent spouse to a refund of those costs during divorce proceedings. Dissipation claims carry strict time limits, requiring you to act within 3 years of discovering the conduct or 5 years before filing for divorce. As for being personally sued because of your spouse's actions, Illinois law generally protects you. But there are important exceptions you need to understand. If your spouse purchased goods or services and failed to pay, a creditor can sue you directly for that debt, even long after your divorce is finalized. Medical debts are treated as family expenses under 750 ILCS 65/15 A1. Meaning Illinois courts have long held that both spouses can be held liable for each other's medical bills. Creditors who wrongly sue a spouse for a non-family expense risk being ordered to pay that spouse's full attorney's fees under the Rights of Married Persons Act, making such lawsuits a genuinely risky move. A written warning citing 750 ILCS 65/15 A2 is often enough to cause a creditor to reconsider pursuing an improper claim against the wrong spouse. If bankruptcy enters the picture after divorce, the timing matters enormously because debts divided in an Illinois divorce decree are generally not dischargeable in a later bankruptcy filing. Once a divorce court allocates a debt to one spouse, the other spouse could theoretically demand repayment, though Illinois, as an equitable division state, would likely consider such a result fundamentally unfair. An experienced attorney who understands the intersection of marital debt, dissipation claims, and Illinois property division law can make a significant difference in protecting your financial future. The Law Office of Russell the 500th, Knight, led by a dedicated divorce lawyer whose practice centers entirely on Illinois family law, is ready to help you navigate these complex issues with clarity and confidence. Call the Law Office of Russell, the 500th, Knight at 773-334-6311, located at 1165 North Clark Street, #700, Chicago, Illinois 60610, to schedule your consultation today.